Sipe has an income only of disability, $1,371 a month. Does your office have any conflict that you know of?
We did have some, the follow was, but that would be one. But
Are we doing the forfeiture today?
I'm sorry?
Are we doing the forfeiture today?
We're first of all trying to find you a lawyer.
Okay, because I need a lawyer for that because we're contesting it.
Do you know if any of the other attorneys locally have a conflict?
probably. Sonny should. I don't know.
What about clerks for lawyers? Do we know any of? I have imposed on him in the past more than I should. So.
Your Honor, if I may, it would be suggested that Ms. Sipe get reappointed the same attorney she had in general sessions, as there was a motion filed for a complex and extended case. If that attorney spent significant time researching this, and additionally, it's one of her pending motions that has not been heard yet. That is Ms. Sipe's second attorney. She had hired her own private attorney at the beginning of it, and then got appointed an attorney once we had the initial first hearing. So it would be suggested that just due to judicial economy, that the same attorney be reappointed as she is familiar with this case.
Your Honor, sorry to interrupt. This is the case I discussed with you, and she is not available for appointment.
Motion for visitation as she promised. Judge Maxey was waiting for it. She told me just to go see my animals, which would be a trespassing charge. So she's trying to get me into trouble. Among with other things that she's done, she doesn't keep me informed. I never know what I'm coming to a hearing for. She doesn't call back. She's been ineffective.
Go see my animals. That's not legal advice. That's a trap. If she's telling her client to trespass, this attorney-client relationship is already on fire.
Give me advice to go see my animals, been a direct violation of law.
We have some.
All right, I'm going to take a short recess so I can review this file because of the nature of these pending motions. We'll take a recess and I will come back to it. I do find Ms. Sipe has filed an affidavit indicating that her total income is $1,371 a month on disability. And for that reason, I find that she is indigent. And I will be appointing an attorney. It's just a question of who I appoint. When you have an attorney appointed for you, Ms. Sipe, it is not always your option to decide that you don't like that attorney. You're always eligible to hire your own lawyer. But if we're appointing someone, then I will appoint someone that I think will do a good job, unless there's some ethical reason that lawyer cannot represent you, and then we'll go from there. I'm going to step off, and Mr. Vaughn, if you need to see me and shame me. Situation is my opinion that the Public Defender's Office does not have a verifiable conflict, at least in this court's opinion, that would prevent them from being able to take the case. And the Public Defender's Office was commissioned by the state legislature to handle cases where criminal defendants are indigent, cannot afford an attorney of their own choosing. For that reason, I'm appointing Mr. Vaughn with the Public Defender's Office to represent you, Ms. Sipe, and then with a, I think this was for arraignment as well, is that correct? We're going to give Mr. Vaughn a copy of the 17-count indictment. And copy of that's being handed, if you will, hand that to Mr. Vaughn.
Well, no, I'll see that here.
All right. Plea of not guilty is entered, and because of the nature of this case and the statutory requirements, this court is required to set a hearing on the bond issue. And so that the record is clear, the bond issue is where the agency that removed the animals is requesting a bond to be posted by the owner of the animals to defray the cost of caring for those animals.
Hold up. The animals might be forfeited if she can't pay. This isn't just a criminal case. It's a race against the bond clock. Tick-tock. Miss CYP.
Pending the outcome of the case, and if a bond cannot be posted, then the animals would be considered to be abandoned under the statute. We're going to have a hearing on that as whether or not that is the appropriate remedy. But we're going to have to give this public defender an opportunity to prepare. So on March 31st at 1 o'clock, we're going to have that hearing. Mr. Willoughby?
We just handed up a motion to correct the typo on the back of the indictment. The wrong name is listed. I don't believe Mr. Vaughn has an.
No objection to that.
I thought I followed on the third, but
And just for my clarification, is it my motion for bond or this?
The motion of bond by the ARC, Animal Rescue Corporation, that has been joined and consolidated with the criminal process. The civil case is also consolidated with this. Mr. Willoughby?
Yes. Which I wouldn't have anything to do with civils.
Well, that's the whole point of what we're doing, but in this particular case, you're only on the criminal portion of it. So, Mr. Willoughby, I need to point something out to you.
Please.
what?
Read your next to the last sentence.
Your Honor, I'm confused.
Just a second. All right. Ms. Sipe, I have appointed the Public Defender's Office to represent you on your criminal case. The motion to correct the indictment will be granted, and it corrects simply the name of the defendant on the back side of the indictment. I've appointed the public defender, as you requested, to represent you on the criminal case. The companion part of this case is the civil litigation that the Animal Rescue Corporation has filed, and it is civil in nature. You are not, under the law, entitled to have an attorney appointed to represent you on the civil action itself. Unless those two somehow coincide, then Mr. Vaughn's representation will be on the criminal matters. And if that coincides, then he can represent you to that whatever extent that he determines that his obligations as your criminal lawyer would involve. But there is a requirement under the statute that we conduct a hearing on the requirement of bond, so that hearing will be heard on March 31st at 1 o'clock.
Your Honor, the forfeiture bond was moved to the criminal side, so Lindsay York was taking care of both of them.
Yes, ma'am, and you didn't want Lindsay York. So I have
I don't
really,
need it.
pardon?
Get anybody, because I can't do that by myself.
Well, that is the law in the state of Tennessee, that you're entitled to an appointed attorney to represent you on a criminal matter. If by constitution you have the right to a criminal attorney. On a civil matter, which is the ARC seizure of the animals and their bond request, that is not criminal in nature. That is civil in nature. And as a result, under the law, you do not have the right to have an attorney appointed for you in a civil matter. So we will conduct the hearing, and you, Mr. Vaughn, can be there at that point to assist you in any way that he feels that his office can do so without circumventing the limits of their representation. If you want to hire a lawyer on the civil matter, that is your choice.
I would rather have Lindsay back to have.
I understand that, but with what you said you wanted and what you said now that you wanted, you don't get to pick and choose, Ms. Sipe. On just when I'm talking, it would be better if you would just stop talking. You don't get to pick and choose your lawyer when you're asking for appointed counsel. If you want Lindsay York to represent you, you can contact her and to make arrangements to hire her as your lawyer on the civil portion of this case, or the criminal case. But as far as appointing her, I'm of the opinion, and unless somebody shows me a law that I'm not aware of, that a civil litigation, is that correct? The ARCs?
Your Honor, case, State versus Tilley, that does address, whether the statute is criminal or civil. And the ruling of that was that this is a pre-judgment criminal. Now, there is not any clarification as far as if she is entitled to an attorney in that regard, but,
Well,
there is.
it has been consolidated by an order of the General Sessions Court with a criminal case. So, Mr. Vaughn, you might want to look into that. But Mr. Vaughn will be here on the 31st. We will conduct that hearing, and your office will be entitled to determine whether or not you have, one, a conflict at all, two, whether or not you can represent her on this bond requirement. But we'll have the hearing at 31st at 1 o'clock.
Alejandro Hermosillo, along with a co-defendant, were traveling through Ashland City and were pulled over for speeding. Upon a probable cause search of the vehicle, the officers did find mushrooms, a Schedule I drug with intent to sell, marijuana of not more than 10 pounds, numerous vapes and THC cartridges with the intent to sell, large amounts of drug paraphernalia to include trays, bags, digital scales, grinders.
Speeding stop turns into mushrooms, marijuana, and a firearm. That's not a traffic ticket. That's a felony buffet. And the cash, over $3,000. Someone was not just driving through town.
And a large amount of cash totaling over $3,000, along with a firearm in possession during the commission of this offense, Your Honor.
Right.
Okay, and Your Honor, the agreement, you want to go ahead and announce the plea now?
Yes, go ahead.
Sorry. Count one, Mr. Hermosillo would be agreeing to plea to attempt to possess Schedule I for resale, Class C felony, be sentenced to 3 years suspended to state probation with a $2,000 fine. Count two, he would plead guilty to possession of a Schedule 6 for resale, Class E felony with 2 years suspended to state probation, concurrent with count one. Count three, he would plead guilty to attempt to possess a firearm during the commission of a dangerous felony, a Class E felony with a sentence of 2 years suspended to state probation. He would forfeit the weapon. Count three would be concurrent with counts 1 and 2. Count four, he would plead guilty to unlawful drug paraphernalia, be sentenced to 11 months, 29 days, suspended to state probation with a $150 fine. And count four would be consecutive to.
All right. You want to hand up that document?
Yes, Your Honor. I didn't have probation.
All right, Mr. Hermosillo needs to come forward and raise his right hand. Raise your right hand and be placed under oath.
Yes.
Thank you. State your full name for the record.
So, yes, Your Honor.
Same full name.
Alejandro Hermosillo.
Mr. Hermosillo, you're here today charged with a multi-count indictment. You've heard your lawyer go over what the indictment is. It's actually a criminal information. So I want to cover with you the rights that you have. Any person who is charged in a criminal case has the right for the grand jury of that county to determine whether or not there is sufficient probable cause for the matter to have charges formally brought into circuit court. You have the right to waive that step and have a criminal information indicating entered in this case. Is that what you wish to do?
Yes, Your Honor.
You talked this over with Mr. Clark, you and he discussed what the advantage to you is, and this is what you want to do. Is that
Yes,
correct?
Your Honor.
All right. Do you understand what you're charged with, and do you believe you and Mr. Clark have discussed it so that you fully understand what you're charged with and what the range of punishment you're facing is, as well as any possible defenses you might have?
Yes, Your Honor.
Well, it's indicated that you want, is this a guilty plea? Do you understand if that you're going to be pleading guilty? Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, Your Honor.
Do you understand if you went to trial, you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Yes, sir.
Do you understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, Your Honor.
Do you understand that if you went to trial, you and Mr. Clark could confront and cross-examine all witnesses the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes, Your Honor.
Do you understand that if you would be presumed to be innocent at trial, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, Your Honor.
You understand if you went to trial, you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, Your Honor.
You understand that by entering this plea of guilty, you're waiving your right to that trial and to the appeal. All I'm going to do is approve what your lawyers worked out.
Yes, Your Honor.
You understand that's going to result in some convictions, and those convictions are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, Your Honor.
You understand everything I've explained to you?
Yes, Your
Do
Honor.
you want to waive your right to a trial and to an appeal by entering this plea of guilty?
Yes, Your Honor.
You understand if you plead guilty, the court of the state may ask you questions about this offense, and if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we discover that you are lying under oath.
Yes, Your Honor.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied that you are in fact guilty of this charge and that that there are facts to support it?
Yes, Your Honor.
Now, you've heard Mr. Hodgson read the criminal information. Are all of those facts true and correct?
Yes, Your Honor.
You want to put any other facts, Mr. Hodlin, on the record? All right. Are you satisfied with your attorney's services?
Yes, Your Honor.
Do you feel like Mr. Clark has done a good job of representing you competently?
Yes, Your Honor.
Mr. Clark, you know of any reason he should not enter this plea?
No, Your Honor.
And Alejandro Hermosillo, on your plea of guilty to count 1, attempt to possess a Schedule 1 drug for resale, I'll find you guilty and sentence you to 3 years, Tennessee Department of Corrections, and will be suspended to state probation. You're ordered to pay a $2,000 fine and cost. Count 2, found guilty, sentenced to 2 years, suspended to state probation. Count 3, you're found guilty.
5 years probation, $2,000 fine, and a forfeited gun, all for attempted possession. But here's the kicker. Count 4 runs consecutively. That's how you turn a suspended sentence into a legal minefield.
Of attempt to possess a firearm during a commission of a dangerous felony, sentenced to 2 years, Tennessee Department of Corrections, that will be suspended. A weapon is forfeited. Count 4, you're found guilty, sentenced to 11 months and 29 days in a county jail, ordered to pay a $150 fine. Count 4 is to run consecutively to counts 1, 2, and 3, and that will be for an effective 5-year sentence. And is that correct?
4 years.
4.
3.
If it's consecutive, count 1 was 3-year sentence, count 2 was 2-year sentence, count 3 was a
2 years.
2-year sentence. Count 4 is consecutive. Count 4 is the 1129. Okay, I'm sorry.
Yes, sir.
That's right, a 4-year sentence.
And it's all probation.
All right, that's the judgment of the court. He needs to see
Thank you.
the probation department. We have some inmates here, I think.
Sign right here that you're waiving your right to go before a grand jury.
You have the criminal information of signing.
You've already waived that waiver. It's just a